Hi everyone, welcome to Active Self-Protection Extra here with Terry Johnson from Firearms Legal Protection. And Terry asked me to talk today about the rules of evidence, and I know we're used to seeing that 404 means file not found, but today it's going to talk to us about how evidence is allowed. Firearms Legal Protection just started a 100% free monthly newsletter to bring quality, accurate information about legal self-defense to good, sane, sober, moral, prudent people like you. Go sign up for free, no-hassle help for your self-defense at the link in the description, and thank them for sponsoring today's lesson. So obviously, Terry, evidence, let's talk about what is evidence first.
Great question. Evidence is what the judge says evidence is. So let me give you an example. The purpose of the rules of evidence is to get in front of the trier of fact, whether it's a judge, whether it's a jury, as pure of information as possible so they can make a decision. And when I say pure, I mean unbiased. So for example, most hearsay is not allowed in court. Why? Because if you tell me that your wife told you that your daughter said that she hates a certain TV show, well, I have no way of authenticating that. The only way I'm going to know that is if your daughter comes and says it on a stand.
Yeah, hearsay is second-hand evidence, right? So that second or beyond hand, it's the telephone game. Well, I heard so-and-so say that they did X.
Right.
No, that's just, you just heard someone say something.
Right. Now, some hearsay is allowed in. I believe there's, 28 exceptions to the hearsay rule.
So there's a whole list of this thing. So the federal rules 404 is what is called the rules of evidence, right?
Well, no, 404 is one of the rules of evidence.
Okay, so there's a lot more. I'm not going to law school, so I don't have all the knowledge of this. I'm not going to law school. So there's a whole bunch of rules as to what is allowed. Now let's think what evidence is. It is that which allows the finder of fact to come to to know truly what happened in a given case.
Well, it's to get in front of the jury the purest facts as possible. So, for example, a guy just can't come and bring a piece of paper and introduce it to the jury, saying, this is a police report. Because believe it or not, police reports are hearsay. A lot of people don't know that. And so, well, how are they hearsay? Because I'm telling the officer something, and the officer doesn't have firsthand knowledge of what happened. So if he comes and he testifies to it, it's not firsthand knowledge. Now, there's some things that can come in from that, yes. 911 calls are allowed in. Why? Because they are business records. Okay.
So how do I determine whether something is allowable or not?
Great question. It really comes down to understanding the rules of evidence. So, for example, if your wife takes a picture of something, how do I, and it's a picture of you holding a gun pointing it at someone, how do I get that in? Well, I've got to bring your wife into court to say, where were you on September 1st? Well, I was here. Did you have a camera with you? Yes, I had a camera. Do you remember taking a picture of your husband? Yes. What was your husband doing at this point? And she will say, now we'll then bring up the picture and say, does this picture accurately reflect the one that you took? And that's a way you get evidence in, and that's why it takes so long for jury trials to go as they do, because the more evidence, unless you have a stipulation. Now, stipulations are when
both sides agree.
Both sides agree that this is going to come in. We try and stipulate as much as possible, but sometimes, one side or the other wants more of a grander performance.
So the interesting part there, I think sometimes, so we go back to My Cousin Vinny, right? And this idea that says, oh, well, I can have this Perry Mason moment where this surprise evidence shows up in court. That's just not possible.
No, that's very, very rare. I mean, you go to My Cousin Vinny, you think about it, the guy with from the FBI, right?
Right.
The objection that Vinny made was perfect. It is, hey, we need to have this evidence beforehand. We should have an opportunity to review it, get our own expert witness to rebut it if necessary. And they just don't show up the morning of and say, oh, here, by the way. Well, in most jurisdictions, I've practiced in a few, you're like, I didn't, what is this? But,
So
you know.
generally speaking, both sides have to disclose. Here's the evidence we want to admit. Here's what we want the jury to look at to see who's done what.
Reciprocal discovery, correct.
Yeah, so this is discovery, right? So they discover. Now, not what argument am I going to make necessarily, but here's the evidence that I'm going to bring
Yes.
that gives me credibility for what I do. Now, of course, physical evidence is going to be a thing, whatever. In a self-defense case, here's the gun that was used. We know that. Here's the dead guy. Right, so we're going to stipulate that, okay, and that bullet was found in that dead guy. All right, we're all in agreement on that. We're not going to argue about that. We don't have to have a grand hoo-ha about it. But perhaps we say, oh, well, so-and-so had a conversation with so-and-so, and we would like that conversation to be entered as testimony. Now we got to talk about, is that going to be allowed?
Right, is it going to be allowed? How about the videotapes? They just, let's say it happened at a gas station, right?
Yep.
You got to have someone from the gas station come in and testify to the authenticity of that particular tape. Yes, I work at the gas station. I'm the person that turned the tape on at 4 p.m. and I turned it off at 8:30 when the police came in, and this is the tape as I remember it. Those are the kind of things that really take along. They just don't say, here's a tape of this guy doing this. He's not guilty, send him home.
So what gets something excluded then? So I think a lot of times what we hear is things like, well, the jury didn't get to hear that piece of evidence. Of course, here in Arizona, one of the big ones, for instance, in the Philip Brailsford case, in the criminal case, he had a dust cover on his AR-15 that he was using on duty. It was a personally owned rifle, and on that, it had a dust cover. Bad words coming, so if bad words offend you, just watch that. Is that when it flipped open, it said, you're fucked.
Right.
On the inside of it. And the jury never got to see that, right? So they had a big argument about whether that dust cover is admissible.
Is it relevant? That's the first thing. Is it relevant to this case? Now, I'm sure they argued that probably under, Herbie, you and I have talked about 404B before, which is evidence of, motive, prior
Depraved
acts,
mind, right?
Intent, things along those lines. And they were probably arguing, well, Judge, it should come in because, it was his intent, because he had this there. You don't have those arguments in front of a jury simply because you don't want to prejudice the jury.
Right.
So if they throw it out, you don't want a juror saying,
yeah, but
he had this and that really stuck in my craw, and therefore, yeah, he's guilty.
So that's when they ask that idea, wait, is it relevant? That's the first one. Is it relevant to what happened? So one of the big ones, 404B, right, is this idea of, well, that guy was a bad person. He was a terrible human, and he had done bad things before.
Yes.
Generally not admissible, because we still have to ask, did he do a bad thing here?
Right, and that's the other part of it. Generally, if someone is charged, you don't really get into their prior felonies. They're charged, for example, let's say they're habitual third. You don't get into the fact that they had 2 drunk drivings before and some other things. It's not relevant to what this person has done, accused of doing today.
The other side of that is, okay, wait a minute. We know this guy was a deadly threat to my client because he had a karate black belt. Well, wait a minute now. Did your client know he had a karate black belt? No, he did not. Well, then it's completely irrelevant because he didn't know that, so he couldn't have used that in his decision-making process in using deadly force. So therefore, the jury is not going to get to hear that this guy was a karate black belt because it's not relevant.
Right, and that's even the case sometimes with expert witnesses. What's he going to testify to? Judge, I didn't get any documents from the expert saying, coming to a conclusion. I didn't get any documents or anything from an expert saying X, Y, and Z. Or here's another one. Judge, this person wasn't on the witness list. I don't know what he's going to testify to. So now that person, well, why didn't you disclose this? So that person is, and even though they can help your case, if the attorney screwed up, that person can potentially be out.
So is the evidence relevant? Does it actually have relevance to the case at hand? Then is it pejorative? Does it, was it known? Does it infect the case or give a bad impression that has no relevance to the actual actions?
Well, and the interesting thing is, we've talked about a judge calling balls and strikes and things like that. And think about the rules of evidence kind of like a baseball game from this standpoint, If I'm playing baseball and I'm in the right, I'm the right-handed box batting, I hit the ball and I run down this way to my left towards third base.
Yeah, wait, you're running the wrong way, buddy. You're going to get thrown out.
Right. So I got to run, rules say I got to run this way, right? And if I bunt the ball, then the rules say certain other things have got to happen. That's how all of this works. And those are the rules that we as attorneys and judges have to follow and have to play by.
So really all it's saying for evidence to get admitted is that it has to be relevant to the case at hand, to the finder of fact, jury or judge, determining what actually happened here and whether it was in line with the law.
And if it comes in, it's got to be in its purest form. And what I mean by that is,
can't be second, third hand.
Can't be hearsay. Is it authenticated? Who's going to authenticate it? I mean, there's a lot of things that have to happen in order for these things to come in.
I'll give you an instance of this actually, which is kind of interesting. We had a case that somebody sent me a cell phone video that I generally don't do cell phone videos on the big channel.
Sure.
Because they have intellectual property attached to them. But the person who took it sent it to me. And it was an assault on a sheriff's deputy in Hawaii.
Okay.
Basically, guy was yipping and all kinds of problems. Eventually, the officer OC sprayed him. He laid down and regretted his life choices. They took him into custody and took him off. Well, that guy, they argued that the officer, that the deputy assaulted him, basically. And so they were trying to establish, okay, wait a minute, what was going on with this guy? Well, I narrated the video and said, well, this guy was an idiot. The officer should have OC sprayed him a whole lot earlier than he did because the guy assaulted the cop several times, the deputy,
sure.
And all these things. Well, I got an email from the district attorney that said, hey, John, this incident is still being adjudicated because this guy is saying that the deputy assaulted him. And so he didn't just say, hey, send me that video. He said, can you put me in contact with the person who took the video?
Right.
Because I need them to swear in and write an affidavit that they took that, this is what this saw. Of course, so this is what I have, sir, here's their email address. And they got into contact, and that person went in and swore out a statement that they took that video this day, this is what they saw, here's where it was, sent them the copy off of their cell phone, and that was instrumental in getting a conviction of this dirtbag.
And here's the other part about that. It's not just that, but if you sit down with 3 or 4 of your friends, you watch a game and everybody sees something different.
Yeah,
the guy was out of bounds. Nope, he didn't catch it. Nope, this happened. It's the same thing with law. We want to make sure, I can call 3 people to the stand who saw the exact same thing, and you're going to get 3 different versions.
Of course.
Especially if you have cops testifying, you're going to get, that's a whole other story.
Which is why you want to get the primary person, right? You want to get that first one who took it, so evidence says. So they didn't just take it off of my YouTube channel.
Correct.
They went to the original person who took it and said, no, yes, I took this video on this date, this is where I was at that time, and this is in that case. And that video evidence was very helpful, but to get it admitted as evidence...
That's what they had to do. Because if the DA would have just taken it off of your YouTube, the argument would have been, well, where'd you get this? How do you know this happened? Who took it?
Yeah.
From what angle? Was it doctored? What was left in? What was left out? As opposed to this person coming to the stand saying, on this date, I took this video, and yes, it represents exactly what I saw.
It represents what I saw with my Mark 1 Mod 0 eyeballs.
Exactly.
Very good stuff. So we want some evidence excluded. We don't want anything that anybody ever could say at any given time brought together because it could poison the outcome.
Yes.
And yet we want the right thing in its purest form presented to the finder of fact so that they can make a good determination.
And that's how our jury system is supposed to work.
So, listen, I know you get frustrated over things like the Brailsford case, and quite frankly, I think at the end of the day, it probably was not relevant what was on his dust cover, because you go, did that speak to whether or not his actions were reasonable in that moment? No, they really didn't. And so the prosecutor had to overcome that and go, okay, no, I'm just going to argue anyways. So the defense attorney said, it's not relevant, it doesn't help anything, but it'll poison the jurors' minds against the defendant without being relevant to the case. And therefore it needs to be excluded, and it was. So they put some like black tape over it and then still showed the rifle in question because the rifle was evidence for what had happened that day.
Absolutely.
So, evidence, crazy thing, more lawyer stuff. I'm so glad I'm not a lawyer.
Not yet.
Not happening.
In the comments, right in.
No. Tell Terry, John's not going to law school. Thanks, Terry.
Thanks, John.